Hi, my name is Megan Lutton and I'm doing this presentation today for the Assessment 2 Legal Research Toolkit. My presentation is on a case management tool I have adapted from the learnings of this course, which includes all the checkpoints required when analysing a case. It is extensive and not all the checkpoints will be used in all cases. This case management tool is designed to be used either electronically or as a hard version, and when checkpoints are not applicable, they can be removed, shortening the case management tool, or be increased to be able to insert more text. I envisage, as my knowledge increases, all the checkpoints will become more concise and easier to use. Essentially, my case management tool will follow the IRAC model and involves following the 5-step process. These 5 steps are: 1. Gathering and identifying the relevant facts. 2. Strategies for identifying the legal issues. 3. Processes for researching the most relevant and up-to-date law. 4. Applying the law to the facts. 5. Communicating to the client in the most appropriate way. Next, we'll have a look at the case management tool, starting with the next slide. Case management tool. It starts off naming the case, date and location. This all helps to gather facts. We want to identify the objectives and point of conflicts between parties. What is your client seeking? What is the other side seeking? By doing this, we want to ask our client involved questions like who is involved to identify all the parties, who suffered and how, why was this avoidable at all, what is the non-relevant information, are we missing any information, and it's important to include specific details like dates and monetary values when collecting all the facts. It's also a good idea to check on alternative dispute resolution to see whether this is a simple matter that can be resolved out of court. It has to be simple. It could be a neighbourhood dispute or a small claims debt that could be settled. Otherwise, if the case is complex, you need to identify the area of law and jurisdiction. So you want to have a look at laws, regulations and precedents. Common law, the decision of the judges in deciding issues, and statute laws passed by Parliament, and go to specific states that it relates to. You want to establish the timeline of relevant facts, so you get a clear idea of when things happened. You also want to establish a burden of proof and response required. What level of response and detail is required for this case? Next, you want to prepare questions if further clarification is required. If you're missing any additional information, you need to go back to your client and seek that information out. You also want to identify the legal issue. You want to identify what has gone wrong, the name of each party and noting their individual issues, and work out what area of law may govern the resolution of this problem. Now, different areas of law can include contract law, trade practices, company law, negligence criminal law, constitutional law, or partnership law. This list is not extensive, but they're just a few areas of law you could be looking at. Next, you want to find the rule. You want to use the purposive approach, and you want to look at the purpose of the Act before interpreting the words. You want to search an online law encyclopedia. Halsbury's Laws of Australia is very good to find law when you're not sure on what you're looking for. Next, you want to research the relevant laws, finding the legislation using OSLI, or you can use the official version of legislation, which is www.legislation.gov.au site. You also want to use intrinsic aids. It's an aid to find the purpose of the Act. So you can find the short title, the long title. You want to have a look at historical versions and view series. You also want to have a look at table of contents and headings. But we don't just want to use the contents. We want to look at the headings, chapters, parts, and divisions to understand the Act fully. Commencement provisions is a good idea to find out when legislation started. Can be some time after royal assent to give those who are affected by the law to get used to new rules. Purpose or object section is a simplified outline. It gives what the Act is trying to do and how. Next, you want to check definitions and dictionary terms to find specific meanings. You also want to find if the Act binds the Crown, and I've made a yes or no comment for this, and it's always important to note that government agents are also bound to the Act. Extraterritorial applications and international agreements. Does the Act extend outside Australia? You need to check for conventions that may also apply. Offence provisions is penalty units prescribed for a person who has offended. The value is based on 100 units. Currently this value sits at 126.15, but you need to check the current penalty unit value as this changes. Operative provisions and clauses. Take notice of operative clauses such as you must, you may, you must not, or words like until, but, or as these aid the interpretation of the Act. It tells you what you need to do. Next is the enabling provision, section 108, gives power relating to the rules of the Act. You also need to check endnotes. It shows acts passed by government, including amended acts and dates of commencement. It breaks down all the sections affected by other legislation and how. Extrinsic aids, which are guides and tools outside the Act, include explanatory memorandum, which is a plain English outline version of the bill. It gives you general outline, costs and ongoing cost, an impact on human rights, a regulation impact statement, why do we need a new law, and is this the best way? Notes on clauses, go through every section and explain why the section is required and what it should accomplish. Next is the second reading speech, which is the introductory speech. You have to be careful because this can contain political views of party and power, but it gives policy and reasons. It gives what it is supposed to accomplish. You can go to the government website and click on bills and more options, and this will bring it up. Interpretation Act 1901 is the master key to unlock all other legislation. You can use the website legislation.gov.au, and I have added some examples for this. International instrument agreements, United Nations treaty or an agreement with any other country. It's a good idea to check if any of these agreements apply to your case. Canons of interpretation are the traditional rules on how law should be read. There's Latin terminology for this. I've added a little summary to remind me of their meanings. Noting up returns every case ever considered. Has the provision been considered by a court? What decision has been made? You can use OSLI website to find noted up references. Delegated legislation is made by public servants. You can read the regulations the same as principal legislation, but note that it has a sunset legislation of 10-year lifespan. And delegation legislation relates to the delegation of powers and requires checking against the Principal Act section 108 to ensure no rules are broken. Lastly, we want to apply the facts. We want to apply the rules to the facts at hand. Do the facts satisfy the requirements of the law? Detail why the client's claims are or not justified based on law. How will this law be used by each party to argue their case? Use the relevant precedent cases or legal principles to support each answer. If applicable, use legislation. There can be several parties involved, so examine each case individually and analyse why the claims are or are not valid. Legal principles and precedent cases are used in each analysis, even if overlapping occurs. This can be applied to both parties. Refer to the reader to another paragraph in the paper rather than rewriting if it requires the same recommendations. Finally, discuss the argumentative parts of the case and not the ones that are obvious or easy to put across. Lastly, we want to look at the strengths and weaknesses of both sides and identify the dispute. And we want to conclude by making a judgment, close off the argument which is the strongest and support it as being the most appropriate answer. State who is liable, for what and to what extent. Consider what parties could have acted to manage their risk and to have avoided the legal problem in the first place. We also want to encapture the reasoning and advise what the outcome is for the client. Thank you.